I'm Doug Lichtman, and in this video, I want to think about patent remedies. Remedies is just this category of what the court can give you at the end of a case. And your remedies might be something like an injunction, where we say the other party must stop whatever the bad activity is. It might be some form of cash damages where the other side has to pay you. Remedies is kind of our response. We've gotten through the case. We've apparently decided that the patent is valid and infringed. Now what? And some of these remedies will be determined by a jury. Some will be determined by a judge. But what I want to focus on here is what can they be? What types of remedies do we see in patent cases? Four categories that I really want to walk through, and I want to start with the possible remedy of a preliminary injunction. A preliminary injunction is different from the others in my list in that it's a remedy that in theory could happen early on in the case. That's why we call it preliminary. And throughout law, you can go to court and say, I know I just sued, and I know we've got a lot more work ahead of us. We might have 2 years of getting evidence and talking to experts and doing document discovery and all this stuff. I know we've got a runway ahead of us, but I would like an injunction now, a preliminary one. Before the court has figured out whether I'm right or wrong, I want to give you enough information to maybe convince you that I'm probably right. And then if I've convinced you, I'd like you to do an injunction now. Stop the bad stuff now. And in a patent case, it would sound like they're infringing my patent. I don't want them in my market. Don't make me wait 2.5, 3 years to litigate. Stop them now. Then we'll keep litigating and we'll figure out if I was right or not. And I guess if I get a preliminary injunction and it turns out I'm wrong, then I'm going to owe the other side money. But the first one I think about is preliminary injunctions. And what do I want to say? I want to say you're not going to get one. And I'm only a little bit exaggerating. Patent courts almost never give preliminary injunctions. And the reason is one of the things courts look at when they're considering whether or not to step in, whether to jump in early, is are they confident about the merits? They don't have to be 100% confident because they have to think about other things too, but they have to feel comfortable that they know that, yeah, in this case, the patent holder is going to win. And in patent cases, it's really hard to get a court to think that way early on. The courts always know that there might be some surprise prior art coming, and there might be some fight about claim construction and all sorts of things. And so they're very reluctant to say early on, I have adequate confidence that I will issue an injunction. I think another reason we don't see preliminary injunctions all that often is the courts think that if the harm is just for a short period of time, a year or 2, 3, and then we'll finish the case. I think courts think, live with it, and at the end, we'll undo that harm. We'll make the bad guy write you a check, we'll make you whole that way. They don't feel intense pressure to jump in right away. This is different from other kinds of cases. In general, in the law, when we talk about preliminary injunctions, one of the big things we emphasize is that there's some harms that accrue that are really hard to fix after they're suffered. We call these irreparable harms. And in other areas of law, we talk about that all the time. We say, gosh, judge, you better step in now, because if you don't step in, I'm going to be hurt for the next year or 2. And there really is nothing you could do at the end of that process to make it up to me. It's really hard for you later to repair these harms. So don't let them happen. Step in now. And again, we see that argument in other areas of the law. In patent law, it's just really tough because the courts are so nervous on the merits. And like I say, I think they largely think, we'll make the other side write your check if that turns out to be the right response. So preliminary relief, I think the right answer is you won't get one. And I'll just add the footnote sales pitch. It's a super interesting area of law in other parts of law where we are going to plausibly maybe give a preliminary injunction. But for the most part in these cases, the answer is no. Actual injunctions are different. Actual injunctions come at the end of the case. So when you litigate the case all the way through and you've proven your patent's valid and you've proven it's infringed, one thing that patent holders often ask for not always, often ask for is an injunction. Make the other guy stop. And sometimes it's because you actually want them to stop. I'm Apple and I've got a really cool feature on my iPhone. Samsung looks like they're doing it too. I've got a patent, and what I want is I want them to stop. I don't want them having that feature. I want that feature to distinguish me from them. And so I actually want an injunction in order that tells them stop infringing, and I might then just write it. Yep, stop. In a lot of cases, though, the injunction is going to be traded away. Patent holder gets the injunction, and what do? They go over to the accused infringer and say, hey, now let's talk. I have a clean legal right to stop you, but what's it worth to you? Will you pay me to take a license, and then I will let you go ahead and continue making your good or service? In a lot of cases, I'm getting the injunction as the first step toward negotiating privately for some sort of cash payment, some sort of royalty, coming back to the private markets. And a lot of patent cases have that dynamic. When you get to the end of the case, you will get one, and I did that with a question mark, and here's why. It used to be, this was a sentence, right? You will get one. Used to be that district courts would look at this pattern of events and say, I'm going to get you through the case, I'm going to figure out who's right, I'm going to figure out who's wrong, and at that moment, I'm going to give out the injunction. And if you're in the bucket of cases where you're like Apple, and you're going to just say thank you, and you're going to sit Samsung down, fine, I'm giving out the injunction, I'm recognizing that the patent is a property right designed to be a really strong legal protection, and we're done. And the courts used to say in the other cases where I give an injunction and I know that what you're going to do is then go sit down over a drink, talk to the other side, and cut a deal. Even in those cases, the courts would say, I'm happy to give out the injunction. And the intuition was that the court wanted the private parties to do that negotiation. If we don't give an injunction, we're going to have to do something, and it means we're going to have to do cash damages. If we get to the end of the case and your patent is valid and your patent is infringed, and I decide not to issue an injunction, then I as the court have to figure out, well, how much money, what's the royalty going to be, what's the licensing rate? And like I say, for the longest of times, the courts would say, I don't want to do that. It's hard enough to get these cases right. It's bad enough that we have no choice but to give out cash damages for things that already happened. Looking backwards, I can't give out an injunction about yesterday. So it's bad enough I have to do the merits. It's bad enough I have to give out cash and figure out what the right number is for things in the past. That's really hard work. Once I've got an answer, what I'd like to do, the courts always used to say, what I'd like to do is give an injunction. And then great, if you guys will go negotiate, that's private parties negotiating. And indeed, this was a very common story in law more generally, that injunctions force private negotiations. And in the patent world, this was viewed as fantastic because we recognize that courts are going to be very bad at valuing patents. What's the value of this one little semiconductor design element that is used inside a computer, that is used inside this other? Really hard to figure out what the right numbers should be. And so for the longest time, the slide would have said, yeah, you'll get one, because the courts wanted to issue the injunction to either, like I say, have the Apple pattern, where the injunction would stop the copying and we're done, or to have a private negotiation. And it's now a question mark in my slide. I'm using a lot of past tense, because in recent years, the courts have softened this approach. Today, at the end of a patent case, you can go to the judge and say, I lost. I get it. You think the patent's valid, you think it's infringed. I've disagreed up to now, but fine. I lost. Your Honor, though, I'd rather you not issue an injunction. I'd rather that you now figure out what should happen next. How much money as a royalty should I pay them to keep going? I'd rather you not give them the power to stop me. And it's been interesting to watch this play out, and I can show you kind of one of the big reasons why. This is just a timeline, like moving through time. And in my timeline, I want to put on the left, first, this the basic idea that I start some business. I start some product. I start doing something, I'm building my item. And right away, after I've gotten my rough sense of what I'm going to do, sure, I get my manufacturing going. I hire a bunch of employees. I sign some contracts about supplies. I make promises to customers. I make a bunch of investments in this product or service. Sometime after that, a legal complaint shows up. Some patent holder sues me. And note, this is a very common pattern in the real world. Up until this moment, I didn't even know about your patent. It's not like I saw your patent, said blah ha ha, and copied it. It's not like I'm reading patents as they're issued and one morning read this and said, oh, I'll do that. A lot of patent litigation shows up exactly in this pattern. I'm doing my own thing. I've got my own product or service. I have no idea that you have a patent relevant to what I'm doing. I start building manufacturing. I start making commitments. I sign contracts. And then once I'm knee deep, I get a legal document in the mail. I'm served. All of a sudden, I've been sued. And then obviously some time passes and there's a ruling. And now we're at this last point in the timeline. And again, the old intuition, the courts would say, at this point, I'll give cash damages for the bad stuff that already happened. I'm terribly sorry, Doug, you infringed, you owe money. And the courts would say, but now that I've made that decision, all I have to do now is hand out an injunction. And then you guys will go talk about it, and you guys will negotiate it. And the old intuition was private parties would do a better job negotiating than the court would. What is the semiconductor worth? Judge has no idea. Let the private parties figure it out. The old intuition was the injunction forced a private negotiation, which might well end in a deal, but the dollar figures let the parties figure it out. That was the old injunction. And what courts have warmed up to in recent years is the recognition that actually this negotiation isn't so good after all. And the reason it's not so good in these fact patterns is those sunk costs. Think what the negotiation sounds like. I get to the end of the case, the patent holder has the injunction, we sit down in a room, and the patent holder says to me, I'm willing to license you. I say, great, how much? And we start talking about how much, and what we want that conversation to be about is the value of the patent. I want to know, what do you have patented? What are my alternatives? Could use your semiconductor. If it's too expensive, maybe it could use this other thing. That would be a really healthy conversation between private parties who understand the technology and maybe would come up with an efficient price, an efficient royalty. That's the dream. But what really happens? The patent holder says, if you don't give me a good number, I can cause you to lose your manufacturing facility. I'll shut it down for a few months by injunction while you redo it. And I can cause you to breach all those contracts you've signed. And I could cause you to idle a bunch of those employees and waste a bunch of those supplies. At this moment in our timeline, the patent holder has two pieces of leverage. The one we want them to have, they won the case. We want them to have control over their technology, which again should lead to a wonderful conversation of what's the value of their technology as opposed to the next best alternative available to you. That'd be awesome. They have that piece of leverage, but the other leverage they have is what I think of as the hostages. Back when you didn't know about the patent, you built this manufacturing facility, you designed it for this purpose, you made these contractual commitments, you bought those supplies, you hired these employees, and all of that can be now held hostage by this injunction. And so what we see is the negotiation is skewed, and it's always skewed in one direction. It's not like noise, sometimes too high, sometimes too low. For the judge, that's true. When the judge is setting the number, we might imagine that sometimes he gives too much and sometimes he gives too little, but on average, he gets it right. So it's not horribly distorting marketplaces. But this one's always distorted. The injunction always gives the patent holder more leverage than they're supposed to have. They get the leverage of their patented technology, and they get the leverage of whatever is taken hostage. Whatever investments you've made that are specific to this technology, you made them when you didn't know, and all of a sudden that stuff is held hostage by the patent holder. Sure, you can go to some non-infringing option, but you'd have to redo your manufacturing, break a bunch of contracts, waste a bunch of supplies. That leverage in certain fights is huge, maybe even bigger than the value of the technology. And so courts began to understand that although our old intuition was, of course we'll give you the injunction. Either you're going to use it to stop the other side, which is your right, or you're going to negotiate, and you'll negotiate pretty darn well. You're a knowledgeable private party. They are a knowledgeable private party. You guys do it. That was the old intuition. We now have courts kind of open to the idea that, you know what? maybe not. You know what? Maybe if we force a negotiation at this stage, the private conversation will be horribly distorted by the possibility of hostage taking. And just to make sure this is clear, compare the negotiation we're talking about at the end of the timeline to the negotiation at the beginning of the timeline. If we were so lucky that this party knew about the patent before they did anything, they came up with their idea and they realized, wow, there's a patent there, the negotiation at that moment would have been awesome. That's the dream. That's the one where we want the private parties to talk to each other, they both know a lot, and it would be the healthy negotiation on the merits. Patent holder would say, if you want to use my technology, it's going to cost you 5 cents a unit. Would-be infringer might say, it's just not worth 5 cents to me. If you need 5 cents, I'm better off using this other thing that's 3 cents. It's not my favorite, but at 3 cents, I'd rather do that than yours at 5. Patent holder might say back, well, if that's true, how about 4? And we'd have a conversation about the merits. What's been patented? What's the next best alternative? And the private parties who actually understand what they're talking about would arm wrestle and figure it out. And what's magical about negotiation here is that our accused infringer is not stuck. There are no hostages. If the patent holder asks too much, our accused infringer walks away and uses the next best alternative. We don't get that at the end. And so interestingly, the answer to injunctions used to be, of course you can have one. Now it's, let's do a hearing. And the lawyers can argue about things like this, like what will happen if an injunction issues? Will it distort the conversation more than what we'd experience if you, Your Honor, were asked to do the really hard, terrible thing of staying involved and making yet another decision, this time about a forward-looking royalty. And you can talk to the court about injunctions versus other things. There are other issues we can raise too. This is the most interesting one and the one that really has changed the law the most. But there are others. For example, it might be I say, fine, you say I'm an infringer, you've proven that up, fine, but I'm making some pharmaceutical. And so you've just shown that my drug falls within your patent. But come on, court, we don't want to take a drug off the shelf. My drug is so important. It's helping so many people. You don't want to have an injunction such that this patent holder can pull the drug and maybe hurt a lot of people. We can now have that conversation. Injunctions are not foregone conclusions anymore. We could tell the judge, here's what's going to happen. In my drug example, we're going to hurt a lot of people. Maybe we're better off with you helping set a dollar figure. Don't let them negotiate with me. They might do something crazy. Judge, you do it. And heck, even put a little thumb on the scale, overpay them ever so slightly, but don't pull my drug from the market. That would be a completely bad outcome across the whole ecosystem. You can think of some instances where I have a story to tell about why an injunction's inappropriate in this particular fight. And the cool thing about modern law is over the last 10 plus years, the courts have opened the door to talking with the lawyers about whether an injunction's appropriate. In the rest of law, that has always been the standard move. Injunctions were what we called equitable remedies. Kind of, is it just, is it proper? And the courts elsewhere in the law would think about what's going to happen. If I give it, if I don't give it, thinking these issues through. Patent law and copyright law, interestingly enough, had both not done that. For the longest time, the patent and copyright courts would say, it's supposed to be a property right. It's supposed to be clean, exclusive rights. And they would just hand out the injunctions like candy. And as I say, in recent years, we've been able to push back a little bit, and the courts now think about it almost the way we do everywhere else. What's going to happen? What's fair? Or what's the implication here? And in a lot of cases, you might still get an injunction. If the patent holder is in the market, wants to shut you down, or if we're in a situation where there aren't really meaningful hostages, or if the injunction can be written such that the injunction phases in over 6 months. How cool is that? If it phases in over 6 months, that might give you enough time to free the hostages. In that instance, maybe the negotiation works great. Right after the injunction issues, I sit down with the other side and I say, look, make me a reasonable deal today, or I'll take the next 6 months, I'll finish with the manufacturing, I'll quietly retool it, I'll use up my supplies, and then I'm not cutting a deal with you. You're going to lose out in the deal because I'm going to go do something else. The courts have gotten much more sensitive to thinking about context, thinking about real implications when we get to injunctions. And so that's been a really exciting improvement, I think, in the way we do remedies. We've done preliminary injunctions, you're not going to get it. Actual injunctions, you used to get it easily, now it's a richer conversation. If we think about damages, and here I want to focus on backward-looking damages, cash damages for what already happened, one of the main theories lawyers get to talk about is this theory about lost profit. And it's exactly what it sounds like. If when you entered the market wrongly, right, you infringed, you entered the market wrongly, your activities cost me profit, I can make it so you have to pay me back. I would have made that sale, you made it, well, pay me the profit I would have made on the sale. You entered the market and that drove prices down. Wow, look at how much you have to pay. You entered the market, you drove prices down. Now for every sale you made, you owe me what my profit would have been. And for every sale I made, you've kind of got to round me up a little bit because I sold at a lower price because you were in my market. Indeed, this is one reason why in drug cases, pharmaceuticals, we tend not to see entry until the case is all over. We don't see what we call at-risk entry. Because who wants to take the risk of entering with a generic drug if, when you lose, you'd have lost profit? Generic drug companies, when they tend to enter the markets, they enter at lower price points than the branded drug. And so if you enter at risk, if you enter at a time when, I might win, I might lose, and then you lose, lost profit math slaughters you. Every unit you sold is quite plausibly a unit they would have sold. So all those units, let's say the market clearing price used to be $10 per pill, you enter as a generic at 7. Well, all of a sudden, for every drug you sold at 7, you owe them the 10. And for every drug that they sold maybe at $8.50, because you entered, so they came down a little bit, you've got to round them back up to 10. So these were $8.50, you owe another $1.50 for every unit they sold. And you're quickly in a world where you're writing a check for way more than you plausibly earned. You came into undercut price, and now you got to make it up to them in all these dimensions. Lost profits can be really big numbers. And as I say, one implication is when you see the case coming, you might well not enter, not take the risk of owing backward-looking damages. You instead litigate, wait till the risk is gone, and you either know, I'm fine, or you know, but guess you can't do that to avoid this math. Lost profits is one way that we run the math to figure out what you might owe. And the law is pretty strict about it. It's really interesting. We'll really check that the original patent holder could have made these sales. Example, TiVo, the company made those cool DVRs for many years. They ended up in litigation against much bigger companies. They said that their patented DVR design was copied by these much bigger companies. And when they won the cases and they get to the damages moment, they were really thoughtful and they said, we actually couldn't have made that many units. We're TiVo, we're small, we had a really good logo and advertising campaign, but we're small. And someone who infringed us, they're huge. So maybe 15% of their sales we should analyze through the lost profit lens. And the rest, the other 85%, let's analyze using a different theory. And they were kind of acknowledging that it's not lost profit if we couldn't have supplied the unit. And courts make patent holders do that thinking. We ask, could you really have manufactured and delivered the units? If so, fine, tell me what your profit would have been. Show me that you would have made those sales, by the way. That but for this infringement, you could have and would have made the sale. And then if that's all true, okay, tell me what your profit would have been and we'll make it up to you. Lost profit also lets you sweep more broadly. If I'm Dell, the computer company, and I would have made a sale of a given monitor because of a patent, and then I could tell the court that when I sell that monitor, I tend to also sell a keyboard and a mouse and maybe the whole CPU. And if I can prove it, that because they entered my market, I lost out not only on the sale of the patented item, but also on convoyed sales, related things in the same convoy that I would have sold, convoyed sales, I can make that argument too. And so lost profit allows us to really ask the question, what profit would I have earned if they hadn't infringed? it could get to a big number real fast. That's one of the cash theories we see a lot of lawyers use when the facts support it. There are a lot of situations when the facts won't support lost profit. Maybe I'm UCLA and I have a patent and you've infringed it, but I don't make stuff. I don't make pharmaceuticals. I don't make widgets. Maybe I'm small like TiVo. I can't make that many units. There are a lot of instances where lost profits doesn't resonate. And in those cases, as we think about what the cash damages should be, the vocabulary, the framing is a reasonable royalty. And the courts have written unbelievable numbers of pages saying reasonable royalty, how do you think about it? And they basically open up the door to a ton of evidence. Whatever, in essence, the lawyers think they might be able to show to a jury and say, you know, based on this document, that contract, and this use, and this expert testimony, I think a reasonable royalty is whatever. The intellectual framing is you're supposed to imagine a hypothetical negotiation between the patent holder and the accused infringer, a hypothetical negotiation at a time just before the first infringement, with both parties agreeing that the patent is valid and infringed. And that's important because we just decided that was true. We're only doing damages math if we decided that the patent is valid and infringed. And so the thought experiment is, if everybody had known that at the time, what would the negotiation have looked like for the reasonable royalty? And we imagine that, and as you can imagine, we're not so good at that, both because it's tough, hard to do those numbers, some nuanced piece of technology and some nuanced industry in front of a judge and a bunch of people who weren't smart enough to get out of jury service. Not clear we're going to get a great number. On top of that, remember the lawyers are all playing strategically. It's not really a hunt for the truth. It's all about how big of a number can I get for my patent holder versus how small of a number can I get for my accused infringer. And I hire my hired gun economics PhD from MIT or Harvard or Stanford or Chicago. And of course, they say something favorable to my side and you hire yours. And it's messy. Let's not pretend it's more elegant than it is. But reasonable royalties is the theory. What would the deal have looked like if we could kind of go back in time and think about what everyone knew and what everyone would have traded off? Remedies, preliminary injunctions, injunctions, and here's the two main measure of damages. Problems. How should we react to all of this? I think there are a lot of problems. I already previewed my concerns with you about injunctions. And injunctions sometimes lead to negotiations that really favor the patent holder, even when we didn't mean to. They can take hostages. For cash damages, there's so many problems. Let me just give you a taste. One problem we see is that juries get too much information. In theory, the judge, before trial, is allowed to act as a gatekeeper. They're allowed to say this evidence is in, this evidence is not. This expert is credible, this one shouldn't be testifying. They're allowed to act as a gatekeeper, and they have lots of power to do so. But what we see is the judges largely don't. They let kind of everything in. And the lawyers then abuse that by bringing all sorts of stuff that's just shiny and exciting and emotional and noisy and make it into a drama and maybe isn't really all that informative as to what the right number is. And as you live these cases, you really are overwhelmed by the thought of, what are we doing? Why is it that we're allowing this information to be presented to the jury? There's only three important moving parts we should have focused the jury on those, and we don't. I think juries get overwhelmed, and again, they get overwhelmed with things that the lawyers pick to manipulate them. The salacious stuff, the distracting stuff, the stuff that maybe if we were sitting down with an unpaid PhD from the University of Chicago in economics, they would walk us through and say, well, that's not relevant, that's exaggerated. But there's no voice like that in the room. The experts are hired guns for either side, the lawyers are hired by either side, and the jury they don't know. They don't have expertise in economics, they don't have expertise in this industry. They maybe don't even want to be there. Too much information is one problem. We don't narrow the playing field in a way that makes this stuff accurate. There's then a related problem, ironically, of too little information. And the too little information problem shows up, all the time. I have a patent. Let's say I have a patent and I accuse your iPhone of infringing my patent. And I get up there, I talk to the jury for 2 weeks about my patent and this detail of the iPhone that it falls within the scope of my patent. And at the end, I say to the jury, it's just one patent, I get it. How about 0.5% of the retail price? Just 0.5%, look how reasonable I am. And what you want to say to the jury is, jury, that cell phone implicates, no kidding, something like 80,000 patents. And so if we gave 0.5% to each of them, we'd be long out of business. What you'd like to say to the jury is, more information. This is but one of a huge pile of patents, because if you think about a phone, it uses a 3G, 4G, 5G. Any of those touches tens of thousands of patents. It uses the MP3, MP4, Bluetooth. It uses certain screen technologies. There's so many things in a cell phone and so many patents around those things that one patent, I'd like to tell the jury, it's just one. And yeah, some of the other ones I've licensed, and some of the other ones might someday come and sue me. Maybe I don't even know about some of them. But you yearn to tell the jury more about the context of how the patent system works in real life, and judges don't let you. If you try to tell the jury there are a couple other patents, the judge will shut you down and say, those patents are not in this case. I don't know if they're valid. I don't know if they're infringed. You can't. And I totally understand that. But imagine asking someone to value the rear view mirror on a car without telling them about the engine. It's really hard to do. Imagine asking them to figure out the value of heated seats without telling them about brakes or cruise control. Sometimes you got to know the bigger picture to value a piece's part, and we don't let juries get information like that. So on the one hand, I worry about they get too much information that maybe is distracting, maybe is salacious, maybe it doesn't actually lead them to good answers because the courts don't act as a gatekeeper to narrow the playing field. On the other hand, where they do act as a gatekeeper, it's infuriating because I think they're keeping away from the jury information that would help the jury see this case in context. Another big problem, jury math. And I could just say jury math and move on, and I think we'd all say, yeah, even us, like I imagine most of us are not phenomenal. Well, I don't know, maybe you are phenomenal at math. I'm actually pretty good too. But asking a bunch of normal people to come in and do math with this many zeros at the end, fighting about hundreds of millions in sales, doing in the context of all this technical confusion, I think that's asking a lot to then say, I bet they can get it roughly right. It's so out of the scope of what a normal person does. You might know your own household budget. You might be decent at that. But a normal person figuring out the value of a technology that's used as a part of a system and a service, I don't know. And I'll tell you even more. I know that the lawyers don't believe that juries can do this math well. And how do I know that? Well, watch what lawyers fight about. Here's a really good example. In a case when we're doing damages math, we often have to say what the rate is, like 3%, 4%, what the rate is, and what's the base. 3% of what? 4% of what? And intellectually, those things trade off. So imagine, for example, I have a patent on spell checkers, and I'm suing Microsoft. I could say the base is Microsoft Word. I could say the base is sales of Microsoft Office, which includes Word. I could say the base is the sale of Windows, which tends to come with Office, which has Word. I could say that the base is Microsoft's total revenue. And whatever I do, you could get to the same number by adjusting the rate. When I'm just focused on Word, your rate would be a certain thing. When I'm focused in Office, your rate would be a little lower. Base went up, rate goes down. If I let you say it's all of Microsoft's revenue, we'd adjust the rate down to reflect the fact that most of that revenue has nothing to do with Word, let alone Office. Fine. You and I, kind of thinking about it, would say, I almost don't care. Tell me what base you want me to use, and then I'll tell you what the royalty should be, what I'm going to advocate. It shouldn't matter all that much. Yet patent holders try their best to get enormous bases. In my example, admittedly silly, they would want to say the revenue of Microsoft. And I think it's because they believe that jurors can't do this trade-off math. Like if I use the entire revenue of Microsoft, the royalty rate percentage has to be really, really low to compensate for the size of that revenue. And I think the lawyers don't believe that juries are capable of doing that, right? 1% sounds like a small number. And it still sounds like a small number to a jury, even if the base goes way up. And they're not going to conceptualize 0.0001% to make the adjustment you need to go. And again, I tell you the story that the lawyers fight for this stuff because it implies that they don't think the juries can do these trade-offs. Jury math. One more, I've got a ton, one more reason that makes me worry about the system is it wasn't my dog problem. We always joke that the lawyer will say, you know, that dog didn't bite you. If he bit you, you deserved it. And by the way, it wasn't my dog at all, right? They get a bunch of defenses. And sometimes they're inconsistent, right? He didn't bite you and you deserved it. And we're okay with that, joking around. But in front of jurors, that's a really tough set of arguments to make. And that's what we ask accused infringers to do. An accused infringer has to get up there and say, the patent isn't valid. If you disagree, though, and you think it is valid, I don't do that way. I don't infringe. And if you disagree with me on that, also, please calculate damages the following way. And I think that's a really tough thing for a lawyer to do and a really tough thing for a juror to hear. Once they've ruled against you on validity and they've ruled against you on infringement, they're probably rolling their eyes as they analyze your damages math. Because you've kind of burned credibility with, the dog didn't bite you, you deserved it, it's not my dog. And so we set the cases up to make it really hard for accused infringers to do all the things that they're supposed to be allowed to do. They're supposed to be allowed to question validity. They're supposed to be allowed to question infringement. They're supposed to be allowed to say, and if I'm wrong in those things, let's talk kind of sincerely about what the economics ought to look like. And I just think in the ground, it's really hard. You'll see some legal teams try to address this problem by having different lawyers speak to different issues. So I'm up there talking about validity, and if you disagree with me, you mentally assign that to Lichtman. And then somebody else has been up there talking about damages, and maybe they're not as tainted with your negative view of validity/Lichtman. You can try, you can sometimes ask for a split trial, although the courts are really reluctant to give it. They don't want to have another jury come in to get up to speed just to do damages. It's a big problem as we litigate these cases. I often tell clients that we got to pick and choose. Let's choose our best arguments, but let's not try to do everything. Because if we try to do everything, we're going to teach the jury that we're wrong. And by the time we get to damages, they're going to learn that lesson and not weigh what we've told them about damages. Lots of things to worry about, I think, in the system. That takes me to my last point. And my last point to you is, once you think about remedies, as we have just done, and you see how hard it is to work with injunctions, because sometimes they give too much leverage. We see how messy it is to do cash damages, really hard questions. It should make us nervous about giving out patents. That's always my takeaway when I think about remedies. We're really bad at remedies, and yet remedies is the thing that gives patents value. Every conversation I have about a patent, if I talk to you about maybe licensing my patent, if I talk to you about something, anything, selling you my patent, threatening you with a lawsuit, anything with my patent, the backstop, the cloud over us is, and if this doesn't work out, we might end up in litigation and I'm going to sue for remedies. And if remedies are so horribly noisy, and they are, and so horribly imperfect, and they are, I think it leads me to want to say, I want to get on that train as rarely as possible. Sometimes I've got to, right? There are inventions that I want to see protected. I want the set of incentives. For great stuff, I'm willing to take the hit, give out a patent, knowing that every time I give out a patent, I put society on a path toward remedies. But if I know remedies are really tough, likely going to be wrong in any given case, will distort things in ways I might not be cheering for. If I know that, I want to think before I start us on that track. I want to think before I give out the patent and maybe be a little more careful, not give it out too readily, not give it out to small things. And that way have a smaller number of situations where I'm giving out a patent and putting society on this path toward remedies. And of course, if I have fewer cases, fewer patents, maybe then I could do a better job on remedies. less cases, less time, maybe society can spend more money to try to get the remedies closer to right in the smaller number of situations it comes up. But big picture, I think remedies are always hard. All over law, remedies are hard. I think they're really hard in patent law. And as I say, that gives me pause about giving out patents too easily. All right, that's your quick introduction to remedies. We talked about some kinds of injunctions, and we talked about two ways of measuring cash damages: lost profit, which can get to really big numbers really fast, and reasonable royalties, which, whether they're reasonable or not, kind of depends on how we end up fighting them out.